you, my lords and my lady. I appear on behalf of the appellant seller, Newstream Trading, and my learned friend Mr Levy QC appears on behalf of the respondent buyer, Naphtha Ltd. This is an appeal against the extemporary judgment of Charles Hollander QC, sitting as a Deputy High Court Judge from just under a year ago. It's an appeal that raises short point contractual construction. I don't propose to go through the simple facts. They're set out in both parties' skeletons, unless you'd like me to.
No, I should say we have all looked at these materials, and so there's no need to go into that sort of detail.
I'm grateful, my lord. Well, on the short point of construction in that case, I have 5 propositions for your lordships and ladyship. The first proposition should be an uncontroversial proposition. It's that if one parks clause 14.5 for the moment, because my learned friend and I disagree about it, if one parks that, there's no other term in the contract that's capable of being construed as setting out a right on the part of the respondent to the return of the advance. I understand that to be common ground. The second proposition my proposition 2 is that the force majeure regime of clause 14 of the contract has the purpose of drawing a line under the further performance of any obligations, but that rights and obligations that have already accrued remain intact. Now, there's nothing particularly earth-shattering about that proposition, because it's what force majeure provisions are generally designed to do. Now, again, if we leave clause 14.5 to one side for the moment, because I'll come to that in my proposition 3, if I can invite you just to look at clause 14, which I'm sure you already have,
Yep.
in the context of my submissions. Core bundle, tab 10. And if we go to page 72, so clause 14.1 is a fairly standard provision, excusing further performance of obligations for any of the reasons set out. Fairly standard. Clause 14.2 is the written notice provision, again fairly standard. One then goes to 14.3. Clause 14.3 provides that the right to terminate, it provides for a right to terminate if force majeure delays delivery by more than 30 consecutive days. Now, in that event, there's no requirement for further performance or any liability for damages. All that remains, and this is at the very end of the paragraph, all that remains are obligations to make payments due under the contract. So, in other words, obligations to pay that have already accrued and fallen due at the time of force majeure termination.
And what payments would they be?
Well, they could, for example, be, if one goes to earlier in the contract, so clause 7.3, there's a requirement for the parties to agree an inspector and bear the costs of those equally. So there's an obligation there. If one party hasn't paid their side of the bargain, that's an obligation that would remain intact. For example, one goes to clause 11.1. That's page 67. 11.1 requires the seller to pay all taxes, customs, and other duties and fees incurred as a result of the conclusion and execution of the contract. That's prior to delivery of the product. Now, if the seller doesn't do that, well, that's another obligation. And clause 5.1, if we go back to the start, we see this is an FOB sale. So the buyer would be responsible for arranging the vessel that would ship the product. And delays in that regard can lead to losses. So just following that through, if one goes to clause 12.3, page 70, sorry, 12.13, my apologies, page 70. And this is just referring to the buyer's nominated vessel arrive other than in accordance with clause 5.3. Delay in arrival results in demurrage or other terminal costs incurred by the seller. The buyer shall reimburse these costs to the seller against seller's invoice. So there are other obligations in the contract. It's not a case of I'm not sure if my learned friend goes this far. I'm not sure if he's suggesting that the only obligation that 14.3 could be referring to is an advance payment obligation. I submit that there are other obligations to the contract that are protected by clause 14.3 proviso that obligations to make payments due under the contract remain.
just taking it a stage further, what about 10.1?
So, my lord, in terms of 10.1, that's the advance payment provision, and the buyer agrees to pay against provision of certain documents that are set out. That obligation has already accrued. It should have been discharged by the time one is into the contract.
And it probably necessarily has, but it hasn't necessarily. I mean, is 14.3 capable of operating in relation to 10.1?
Well, my lord, if the advance payment is not made, then and I have to remind myself of where it sets this out in the contract, but it would be open, if I go to the termination provision, so it'd be open to the seller to terminate. Let me just check before I make that. So clause 20.2, there's a right to terminate in the event that payments aren't made when they should be made.
But the ideal from the seller's point of view is to say, well, there's force majeure, I don't need to perform anymore, but there's still an obligation on the buyer to pay.
Well, my lord, if one were in the situation, so I suppose the way I would address your query is that it's unrealistic that one's going to be in that situation, because the likelihood is the contract would have been terminated if the buyer hadn't paid the advance. But theoretically, if the seller was happy to run along without an advance being paid, and then force majeure was declared, then, my lord, I suppose that would be an obligation that had already accrued. But
so he could insist on getting in however many millions of dollars, even though the contract was by then dead.
Well, my lord, I'd have to. It is just. It's a situation that is.
You say it's unreal.
It is unreal. It wouldn't. If any obligations that have accrued remain protected.
Yes.
And the example your lordship has given me is, I submit, theoretically possible, in that if the obligation has accrued and the seller has been prepared to run along with the contract without exercising their right to terminate or to threaten suspension or something, then that would be an obligation that's accrued and would be protected under clause 14.3.
Yeah.
And I submit the consequence of my proposition 2, that the force majeure regime essentially draws a line under accrued rights and obligations, is that once force majeure is engaged, one wouldn't expect from that point in time on for any new rights or obligations to be created, absent, I would submit, clear language. That then brings me to my third proposition. And my third proposition is that the language of clause 14.5 is about preservation of rights, not the creation of rights. Now, the key word in clause 14.5 is impair. Impair is, I submit, the language of preservation, not the language of creation. And I submit that is consistent with the purpose of a force majeure regime, and it's consistent with my proposition 2. And just developing my third proposition, I submit that the key word impair is not susceptible to more than one meaning or interpretation. There's no ambiguity or uncertainty as to whether the term impair embraces something other than preservation of existing rights and obligations. And if the term isn't susceptible to more than one interpretation, well, one doesn't get into the territory of interrogating the clause by reference to the implications of competing commercial constructions. That is, I submit, modern construction orthodoxy now, after Rainy Sky, Arnold and Britton, Wood and Capita, that my learned friend and I haven't troubled you with because we agree the principles.
Yes.
Now, my learned friend may, just anticipating what he may say, is he may point to what follows the word impair and say, well, if you look at that, look at the rest of the clause, and it suggests that the clause is open to more than one interpretation. If you were to say that, I'd respectfully disagree with him. Impair is the operative word. It's the verb. It is, I submit, the fulcrum of the clause 14.5 provision. And one cannot permissibly force ambiguity into the meaning of an otherwise unambiguous word, impair, by pointing to what follows in the sentence. So, for example, just because the word impair might be followed by a reference to an indemnity or a claim for damages, it doesn't follow that the word impair should now be read as creating a claim for an indemnity or damages. Because to allow that to happen would, I submit, be an egregious instance of the tail wagging the dog. And I've given you the example of the claim for damages or indemnity, two things that don't exist. But just looking at this contract, that one of the things that follows is the defined term outstanding advance amount. Now, it should be common ground that there's no such defined term in this contract. There may be in some other contract, but not in this contract. It doesn't suddenly end up being created because it follows the word impair. So in my submission, from a textual and natural reading point of view, which I submit as the correct starting point of the analysis, one cannot read impair as creating a right to the advance payment. I pray in aid of that submission the fact that Mr Justice Andrew Baker formed a similar view in the Totser and Newstream trading case. He held in that case, the view held as putting it high with no bit of comment. He made the comment in that case that the equivalent of clause 14.5 didn't create a right to the return of the advance, it merely preserved a right created elsewhere in the contract. Now, I'll take you very briefly, if I may, just to the Totser case. It's in the authorities bundle behind tab 9. The facts were very similar to this case. So we see from paragraph 1 there was a contract for sale of 30,000 metric tons of product, slightly different product but same quantity. Paragraph 3 sets out the terms of the contract, and they were very similar to the present terms, save that. Clause 10.1, the advance payment provision, is slightly different, because in that case, presentation was to be against seller's provisional invoice. The comfort letter is slightly different. It's a comfort letter in favour of the buyer in the agreed format acceptable to the buyer and the seller, and a signed contract rather than draft contract. So 10.1 is a little bit different. Then if one turns forward 2 pages, one has clause 10.18. And clause 10.18 gave an express right to the buyer to the return of the advance payment. And that was in all situations, not just force majeure, any situation. And it was this provision, 10.18, that set out the defined term outstanding advance amount. Now, as to the force majeure regime, if one turns the page, clause 16 was the force majeure regime, and it appears to be identical to clause 14 in our case. And clause 16.6, which is at the bottom of the following page, contains, again, the equivalent of clause 14.5 in our case. Now, if one goes to paragraph 4 and 5, an advance payment of just under $14 million was made by Totser as the buyer to my clients, Newstream, as the seller. Newstream declared force majeure. It was treated as valid force majeure for the purpose of the summary judgment application, as here. And then if we go to paragraph 8, Totser then made a claim for the return of the advance under clause 10.18 and sought summary judgment on that claim. We can then go forward to paragraph 20 of the judgment. And this sets out the analysis of the case ran by my clients in that case. So Newstream's argument was that because the only pleaded claim was under clause 10.18, if following a force majeure termination, any rights to the advance didn't arise under clause 10.18, the claim must fail. And their argument was that clause 10.18 didn't apply in a force majeure situation. Mr. Justice Andrew Baker rejected that argument. Paragraph 21, he took the view that clause 18 was the agreed repayment provision, the advance, both in a force majeure situation and a non-force majeure situation. and he rejected the argument that the introductory wording of Clause 10.18, when read with Clause 16.16, meant it didn't apply. What I rely on, my lords and my lady, is paragraph 23. There, the learned judge accepted New Stream's submission that the Clause 16.6 language did not create the obligation to repay. Then he held the source of the obligation to repay was obvious, as we found in Clause 10.18. Now, my learned friend says there was no contested argument as to whether Clause 16.6, 14.5 in our case, created an obligation to repay the advance. I accept that, there wasn't. And he says that there wasn't that argument, the judge didn't need to consider the argument because of the presence of Clause 10.18 in that case. Again, I accept that. But I submit this case remains of persuasive value that Mr Justice Andrew Baker regarded the language of Clause 16.6 as not itself creating an obligation to repay. And so I would continue to say the fact that we don't have the equivalent of Clause 10.18 in this case doesn't alter the fact that from a textual analysis point of view, the word impair cannot fairly create an obligation. And I submit Mr Justice Andrew Baker was right not to read it as doing so in the Totzer case, and there's no sound reason to read it as doing so in this case. And so I submit the learned judge in first instance was wrong to conclude that Clause 14.5 did create an exception.
As you're recognising, our clause has a different context. Maybe the same words, but the context is different. And plainly, when you're construing any clause, you have to look at the context.
I accept that. But the starting point is still the language. The context. I accept the context is different. I submit the context isn't so markedly different from the Totzer case that one should read the word impair, or that one can legitimately read the word impair as meaning something more than impair.
I mean, looking at it in a very broad brush, common sense way, might one infer that what has happened is that in the context of this contract, the seller wasn't prepared to accept an obligation to repay in all circumstances, but force majeure was carved out.
Well, my lord, to some extent, then this is where one gets into the
negotiation.
Yes. That my learned friend. I'll come to that in a moment. What my learned friend criticises my drafting history point, but that point, as I hope to explain, is more responsive to the way he puts his case.
Yes.
But if I then move, so that's my proposition 3. If I come to my proposition 4, so the fourth proposition arises if your lordships and ladyship aren't content to accept my proposition 3 as representing the end of the construction analysis. So in that event, the court would interrogate clause 14.5 by reference to the competing instructions. So my fourth proposition has 2 limbs. Limb A is the judicial creation of a substantive right where one is not set out expressly is, to use the vernacular, a big deal. And limb B is that the creation of a substantive yet unexpressed right is not the preserve of construction, but of implication. An alternative would be rectification, but that's not in play here. So just taking the first of those, my proposition 4A, that it's a big deal. I say that because there are repeated references in the authorities on construction and implication to the effect the court will not seek to improve the party's contractual bargain. And therefore creating an unexpressed substantive right is something about which the court should be circumspect. All the more so when one is dealing with sophisticated commercial parties that are well able to understand risk. I submit that any intervention by the court that creates an unexpressed substantive right brings with it a high risk of improving the contractual bargain for one party or the other, in a way that I submit should be impermissible. And then I'll return to my proposition 4A in a moment, but just before I do, I just put down the marker of my proposition 4B, which is that actually construction is not the right way to look at this. Where a party is trying to fill what's said to be a gap or hole in the contract, one has to go to implication with the higher requirements that requires. And Lord Newberg alluded to that in Marks and Spencer. We don't need to take you to the paragraphs. What my learned friends seek is the creation of substantive right. One's not talking here about using construction to define the scope of an existing right, or to define the limits of an express exclusion. And also, this is not a case where my learned friend is seeking to read in a procedural right, such as a right that a party will not exercise a substantive right unless some process is followed. This is the actual substantive contractual right that they're looking to bring in. Now, in that regard, the only other authority I wanted to refer you to was the U-Design case. It's in the Authorities Bundle, tab 10. It's the latest statement on implied terms. This will all be very familiar to you all, so I will be very quick. If you can pick it up at paragraph 47 of the judgment. And paragraph 47 of judgment, Lady Justice Carr introduces the implication of terms as being, this is the distinction I alluded to earlier that Lord Newberg mentioned. And I submit that the cautionary note in paragraph 47 about this being potentially so intrusive, that applies a fortiori where the suggested implication is of a substantive contractual right rather than a procedural contractual right. Then one goes on, paragraph 50, Lady Justice Carr quotes from Lord Hughes' judgment in Ali and Petroleum Co. Of Trinidad. And I just underscore the point that it's not enough to reiterate the process of implying a term into the contract must not become the rewriting the contract in a way which the court believes to be reasonable or which the court prefers to the agreement which the parties have negotiated. And I submit, my lady, my lords, that is an important point to have in mind. Any court can look at an agreement and think this could have been done much better. Any sensible party would have negotiated something much better for themselves. That can't be your guiding star. And paragraph 51 sets out, Ladyship summarises the principles about which there's no dispute. Returning then to my proposition 4A, my big deal submission, and this is by reference to the process of construction, and just to be clear, that's without prejudice to the fact that I submit that's not the right way to go about it. If your ladyship and lordships wish to interrogate the consequence of competing constructions on clause 14.5, I'd make the following points. It's unlikely to be controversial between us that clause 14.5, the contract, is inelegant and doesn't fit all that comfortably with the rest of the contract. The learned judge made the same observation in the first instance. Now, the parties each posit explanations for how the court should square that circle and how the inelegance came about, and why clause 14.5 might be there. Now, I submit that in assessing the explanations, your lordships and ladyships should be slow to opt for the explanation that involves the greater interference with a party's written bargain. And in that regard, the respondent's argument requires the court to create an unexpressed substantive right to the return of the advance. There is, I submit, possibly no greater interference with the expressed bargain through a process of construction than to give one or other party an additional substantive right. My learned friend then says, as against my construction, that it essentially renders a large part or all of clause 14.5 OTOs if there's no obligation to repay the advance payment. Even if that's correct, I submit that is the lesser evil in creating a right that sophisticated parties have chosen not to express. And that's an important factor when analysing the competing constructions, and I submit a factor against reading an unexpressed right into clause 14.5. In addition, my lords and lady, I submit on my learned friend's case, the right to the return of the advance would arise and be created in clause 14.5. So it would be a right that arises or is created on force majeure termination. And I submit that's counterintuitive to what force majeure regimes are designed to do, my proposition 2. And one would expect much clearer language if a new right was being created on force majeure termination, I submit.
Why is that improbable?
Well, because once the force majeure regime kicks in, my lord, I submit what is happening is there's an honourable stalemate between the parties, that there's nothing further to be done. The idea that at that point one or other party is given a new right that they didn't have that hadn't accrued at that point, is, I submit, a counterintuitive proposition.
I mean, might one not rather say, well, if it turns out this contract can't be performed, everybody should go back to the beginning and the money should be repaid?
Well, my lord, one can only really go with what is set out in the contract. And
absolutely. A way of expressing it is what would a reasonable person with all the background have understood the parties to be using by the language that they used. But in deciding that, the reasonable person will have in mind what is inherently probable, won't he?
yes.
And he might regard it as inherently rather improbable that you were to keep all the money and not provide anything.
Well, my lord, in respect of us not keeping all the money, I'll come to that in the context of my when I deal with the implied term. But just to give you a foreshadow the point, one of the points I'll be making, I'll be submitting that the parties knew that the advance would not be held on to by my client as such, but passed on to the refinery. So this wasn't a case where the money would be paid to my clients and they would bank the advance.
But the reasonable person would think, well, I don't actually know about how the relationship between you and the refinery works. I do know that the refinery is under no obligation to repay in the event of force majeure. So the reasonable person thinks it's not very likely that the buyer intended to be left in a position where he had no right against anybody to recover the money that he'd paid, and he wasn't getting anything.
Well, my lord, I suppose one starts with the language, and one has. I've made my submissions about the clarity of the language, and then one goes to the competing commercial constructions, where my learned friend's argument and what your lordship is driving at is that there must be something in. The parties must have intended to put something in there to cater for this.
Well, they did. They put in clause 14.5. You said they used a silly word in impair. But, I mean, otherwise, on your construction, 14.5 is meaningless.
Well, yes, my lord.
And, you know, it is possible to have a meaningless phrase. We all know that. But it's pretty unlikely when you've got, as you rightly point out, excellent lawyers on both sides.
Well, my lord, that then comes to the extent to which, and the debate that we enter into as to the extent to which an argument from redundancy or presumption against surplusage becomes a legitimate basis to read a right into the contract, to create a right.
And I mean, what the authorities show is that that's a pretty weak pointer, the surplusage.
Yes, so and there's no real dispute between my learned friend and myself on the law on this.
No.
That the idea that this clause might be OTO is of limited assistance to you when construing this provision. So ordinarily, the fact that some or all of clause 14.5 might be rendered OTOs shouldn't materially affect your lordship's or your ladyship's view. Now, my learned friend says that this case is different, and I'd just like to take you, if I may, to why he says it's different. And it's in his skeleton, so the core bundle, tab 5, page 50. Paragraph 22. And so my learned friend's argument is that parties to a commercial contract do not go out of their way to preserve rights which they do not believe to exist. And the fact they have gone out of their way to preserve the right must mean, on any objective reading of the contract, that they acknowledge the right did exist. Now, it's at this point in the analysis that I make my submissions as to why we may have clause 14.5 in the contract, and why there's no warrant for assuming, as he does, that the parties went out of their way to include clause 14.5, preserve rights they believe to exist. And there are two strands to this. The first strand is my reliance on the Totzer case. And I submit the Totzer case gives us an idea as to how clause 14.5 appears to have been intended to operate with an express counterpart provision earlier in the contract, clause 10.18 in that case, which we don't have in this case. Now, my learned friend says, well, that's just speculation. And he criticises this part of my submissions as being called them drafting history. But my point is I submit merely the obverse of his point, which is that the parties deliberately included this term and they went out of their way to do so. We have no evidence of that, of how insistent or not they were about including clause 14, or about how much they went out of their way to do so. So That's also speculation. What we do know is that clause 14.5 doesn't fit comfortably with the rest of the contract, and the Totzer case gives us a credible explanation as to why that might be. So my submission is responsive to my learned friend's submission, and I submit that so far as he's using this idea of the parties deliberately went out of their way to include this, that is an unsafe building block on which he constructs his construction argument. The second strand that I raise in response to this point is that another reason why the contract does not or might not contain an express right to return the advance is the comfort letter, an understanding that the parties agreed a scheme whereby the respondent would look to the refinery for the return of the advance in the event there was a short delivery or non-delivery, including for reasons of force majeure. Now, my learned friend makes the point that the refinery could terminate the comfort letter in various circumstances, including in the case of force majeure. So he says, not much use. Now, what that comes down to, I submit, is whether the comfort letter was a solid method of protection. And he says, well, it wasn't a very solid method of protection. As to that, I submit it was the method of protection contractually agreed. And again, it's important not to seek to improve the parties' contractual bargain. So clause 10.1, the respondent in this case agreed to a provision whereby the format of the comfort letter only needed to be acceptable to the refinery. If that wasn't acceptable, they could have negotiated a different provision in clause 10.1 but chose not to, unlike Totzer in the other case. And so, my lords, my lady, it might be a bad bargain, but it doesn't undermine the contractual intent on this part of my submission. The buyer would look to the refinery.
Let me put it differently. Clause 14.5 is part of a clause dealing exclusively with force majeure. So the comfort letter provides specifically for that situation, saying that the refinery can cancel.
Well, yes, it does. It contains a guarantee and a primary obligation. I'll show you in a moment, the comfort letter, which would require the refinery to refund the advance, either if Newstream didn't deliver product for any reason, or if there was short delivery. And that covers all situations, including force majeure. But there's a clause 9, my lord.
Saying you can cancel.
Yes. So if one.
So the reasonable party, reasonable buyer entering into this contract thinks, in the particular situation for which clause 14 caters, the comfort letter is no comfort at all. And the very fact that the comfort letter is only to suit the seller and not me is consistent with my not getting any comfort from the comfort letter in relation to the situation for which clause 5 caters.
But my lord, I submit that is the comfort that you have agreed. You could have agreed.
Quite. So that's the comfort you've agreed, but you know that that comfort doesn't help you in the situation for which clause 14 caters. Therefore, it might be inferred that you intended clause 14 to cater for that situation.
Well, my lord, I see the argument, but I submit it still comes back to the point of you have provided for a method of recovery direct against the refinery. That
in situations other than force majeure.
And force majeure, and that may not be very effective protection, but it's what you've agreed. In any event, my lord, I submit one can query the extent to which it's safe to assume that the comfort letter wouldn't be available. I appreciate this is of limited relevance to construction because it does involve post-contractual events, but as a matter of fact, the comfort letter was extended the day after force majeure was declared. So force majeure was declared on the 17th of April 2019, and on the 18th of April, the force majeure, the comfort letter was extended. So it may be the parties would reasonably have had in mind the comfort letter was worthless in a force majeure situation, but that may not be a safe assumption to make, just on the basis of what we know did in fact happen.
Well, the refinery hasn't repaid as far as I know.
The comfort letter expired anyway, didn't it? I mean, long before the force majeure was accepted and the contract was terminated, wasn't Does it expire on the 15th of May 2019?
So there was an original comfort, that's correct, there was an extension to the comfort
Yeah,
letter.
which has all been and gone and finished, hasn't it?
It's
Long before, wasn't that before the contract was terminated? Page 88. On the expiry date,
Yes.
the letter becomes accomplished, null and void. No claims arising out of or in connection herewith shall be accepted by us. So
the termination took place after that date.
If it assists, it was extended by 1 month.
yeah,
It was extended until May,
yeah,
Yes, I mentioned that.
and then after that,
there's nothing.
no, there's nothing after
Thank you.
that. And we see that at behind tab 12.
Yeah, I think I'm looking at it.
Oh, I see.
I think that's where I am, page 88. But it's not much of a comfort, really, is it?
Now, in respect to the comfort letter, I would just make a very quick observation. I don't wish to dwell on it much longer. But behind tab 11, the two obligations that the refinery are under are set out clauses 4 and 5. So clause 4 is setting out a guarantee of New Stream's obligations to supply the oil up to the value of the advance payment. So on that basis, the primary obligation would be with my clients, and if they fell short, the refinery would guarantee that, up to the value of the advance payment. Clause 5 is slightly different. That sets out a primary obligation on the part of the refinery. The draftsman's aware of the concept of guarantee, but this isn't a guarantee. So it's not guaranteeing the return of the advance by my clients. It's setting out a primary obligation to provide the advance. And the second paragraph in clause 5 mentions that it'll be paid directly by the refinery into NNL's bank account. So I submit, I hear what your Lordships and Ladyships say about the comfort letter, but I submit that it provides at least an explanation, a sound explanation, why the contract didn't contain an express right to the return of the advance, because, at least in part, that was understood to be catered for by the comfort letter. I then come to my final position, my proposition 5, and this follows on from my 4b, which is that implication is really the way to look at this, not construction. My fifth proposition is that looking at this from the point of view of implying a term into clause 14.5 or into the contract generally, the tests of business efficacy and obviousness are not met here. So, as Lord Newberger said in Marks and Spencer, and Lady Justice Carr reiterated in the U-Design case, one would usually expect both the business efficacy and obviousness test to be met for terms to be implied. And it would be, in their words, a rare or unusual case where it's one but not the other. I submit there's nothing rare or unusual about this case, so my learned friend's clients would have to meet both tests. As to the business efficacy test, I submit it's not necessary for such a term to be implied. The contract remains commercially and practically coherent without it. The fact that in a particular eventuality one party doesn't recover an advance that they've paid doesn't render the contract commercially or practically incoherent. And I submit all the more so where that eventuality is a force majeure situation, which itself is an extreme event. So I submit my other friends' clients can't get over the business efficacy hurdle, and if that's the case, that should be the end of it, because both tests need to be met. As to the obviousness test, I submit it's not obvious that such a term should be included. And I submit the parties would have been aware that the advance would be passed by New Stream to the refinery. My learned friend makes the point, and your Lordships made the point, that the contract and comfort letter don't expressly require the advance to be passed on by New Stream to the refinery. As a matter of fact, that's what happened, but I submit that that's what the parties would be aware, so the parties would be aware that that is what would be happening. It's part of what they could reasonably have known, I submit, at the time of contracting. Because the comfort letter is drafted on the basis that it will only take effect once Nord Naphtha has paid the advance to New Stream. That's clause 7. And then one has the provisions we just looked at about the refinery returning the advance in certain circumstances. And I submit on a natural objective reading, it would be apparent that all of that would have been because the advance would have been passed on. And I submit it's not obvious in that situation that when New Stream no longer has the advance in a force majeure situation, it would be expected to refund that amount. One asks rhetorically, why is Newstream better placed than NNL to insure against the risk of the refinery having a force majeure event? And so I submit it's not obvious, and all the more so because the parties had agreed a scheme under the comfort letter where Lord Naphtha could look at the refinery, even if it was an imperfect scheme. Unless I can assist you further, those were going to be my short submissions.
Sorry, can I just ask, just so that I make sure I'm accurate about your last submission? You say that it wasn't expressed that the money would be passed on either under the original agreement or the comfort letter, but it was at least implicit from clause 3 of the comfort letter. Is that how you put it? Sorry to ask.
No, my lord. So I accept that there's no express language in either of the contract or the comfort letter that obliges my client to pass the money on, the advance on to the refinery. But I submit that just from the language of the comfort letter that would have been available, so the comfort letter would have been available to the claim, my learned friend's client at the time of entering into the contract. It's apparent from the language of that comfort letter that it's not going to take effect until the advance is paid, and it sets out provisions whereby the refinery is returning that advance directly to Lord Naphtha. And I submit all of that would have rung a bell that that's because the advance is going to be passed on by my clients to the refinery.
Thank you.
That's very clear. Thank you very much. Mr. Newey.
My lords, my lady, I'm going to take the role of a true respondent in this case, and I'm going to make my submission simply by reference to what my learned friend has just said and respond to each of his points in the order that he made them. His first proposition is indeed uncontroversial, that there is no other clause other than clause 14.5, which we rely on as creating an express right. So far, so good. The second proposition, I'm afraid we part company immediately at his next point. Well, we don't actually part company. His second point was that accrued rights, and only accrued rights, have been preserved and nothing else. Well, we accept that, but I'm afraid that submission, along with, in my respectful submission, most of my learned friend's points, are question-begging, because he begs the question about whether the obligation to repay existed or not. And so his submissions proceed on the basis, well, they didn't, and therefore what was being preserved were only the rights which existed. But that is the issue that your lordships need to decide, and indeed the issue that Mr Hollander has already decided in our favour, namely that such a right did exist. The second point I would make in relation to heading 2 would simply be to, with respect to adopt my Lord Justice Newey's point, that it goes too far, my learned friend's submissions, because on his analysis, under clause 10.1, the obligation to pay the advance would still exist. And my learned friend says, well, that's all very unrealistic. But why is it unrealistic? Because it may well be that the seller decides, the buyer says it's got difficulty paying, let's say it's a long-standing relationship, and the seller says, well, we'll go ahead and we'll take it on trust that in a week or in 2 weeks' time you will pay the advance, because that's what you've always done, and we accept that so. There then comes along a force majeure, and we're then in the very situation that my Lord Justice Newey posits, that the obligation to pay the advance would exist and could be enforced by the seller in circumstances where it was common ground that there was a force majeure and we were going to get nothing in return for our money. The third point that my learned friend makes is on the language of clause 14.5. And he says that the word, we should focus on the word impair, and that's all there is. And he says that the language is plain and clear, that it's a preservation of rights and not a creation of rights. Well, again, with respect, that's question begging, because what we say is that properly understood, the word impair in this context, and particularly read with the words the obligation and under the words under the contract, so just picking up the express language of clause 14.5, what we see, if one reads on in the clause, nothing shall impair the obligation by the seller to repay the amount. So in other words, it's not any obligation or an obligation. There is nothing shall impair the obligation to repay the advance amount.
Is it not
Plural.
obligations rather than
Plural
obligation?
Oh yes, but it's in relation to two things. One is the amount of the advance payment or any outstanding advance amount. So there are two things that are there. One is the advance repayment, and the other one is the advance amount repayment under this contract. And I stress the words under this contract. Now, it is true that actually the outstanding advance amount is not defined in this contract. Those words arise in the comfort letter. But in a sense, on my construction, one can ignore that for the moment, and one can see that what is clear is that nothing impairs the obligation to repay the advance payment, the obligation under this contract. And so we say that this is certainly not a case, as my learned friend puts it, say, oh, well, it's clear, we're just talking about impairment, and creation doesn't come into it. So don't accept the premise of his point, which is, he says the language is clear. So that's my first point. But the second point I make in response to my learned friend's submission is that as a matter of law, with respect, I don't accept what he says, is that even if the language was clear, that one doesn't get into questions of what is the commercial context of this agreement. And we see that from Wood and Capita, that what the Supreme Court said in Wood and Capita is that construction is a unitary exercise, where one looks at two things. One looks at the language, but one also looks at it in the context of the clause. And I don't know whether I'm sure your Lordship and Ladyship are very familiar with Wood and Capita, but for what it's worth, I don't mean for what it's worth because it's not very important, but because it is so obvious or so well known. The passage I have in mind, it's behind tab 7 in the authorities bundle, and it's page 105 of the bundle reference, but it's really at the letter F at page, in the report at letter F, we can say there's a unitary exercise where there are rival meanings. The court can give weight to the implications of rival constructions by reaching a view as to which construction is more consistent with business common sense. And then if one drops down to paragraph 12, this unitary exercise involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial consequences are investigated. To my mind, once one has read the language in dispute and the relevant parts of the contract that provide its context, it doesn't matter whether the more detailed analysis commences with the factual background and the implications of rival constructions, or a close examination of the relevant language in the contract, so long as the court balances the indications given by each. And so the court, when construing a contract, is involved in not just in focusing simply on words alone, but also on the context of the contract. And can I just make, as an aside, I do note that the way my learned friend put his case in his skeleton argument was very much on the basis of what he called, he hasn't referred to it today, as the back-to-front approach. What he says was that Mr Hollander got it back to front because he started with commercial consequences before he looked at language. And that, with respect, is a bad point, because what the Supreme Court is saying in Wood and Capita is it doesn't matter. But obviously Mr Hollander was struck by the commercial consequence of my learned friend's construction, and that's why Mr Hollander approached it in the way that he did. But as to the way my learned friend puts it now, he says, well, if the language is clear, that is the end of the matter. We don't accept that.
A slightly different way of putting it is, well, the word impair might be unambiguous in a different context.
Well,
but in this particular context, with not only the background commercial sense of it, but the words that follow the word impair,
I accept that.
there is an ambiguity.
Well, my lord, I accept that. We don't put it as ambiguity.
No.
We put it as you're just construing the word impair in its context. But I can certainly see one can advance a case that the word impair, taken alone, if one looks at the dictionary definition of the word impair, I haven't checked it, but one's unlikely to see the word create. It is preserving something that exists. So far, so good. But then one has to interpret that word in its commercial context. And that's why one does have to look, A, at the commercial consequence, and B, as your lordship says, as the other words, and the words that I've drawn attention to, the obligation under the contract. My learned friend, under this heading, dealt with Totsa. And he fairly accepted, as he was bound to do, that the point in Totsa that I'm advancing wasn't argued. It didn't need to be argued because they had the benefit of an entirely different express, an express clause. They had a different express clause. We say that clause 14.5 is an express obligation, but they had a different obligation clause that they were relying on. My learned friend says, well, it remains of persuasive value. Well, with all due respect, so does Mr Charles Hollander's decision in our case remain of persuasive value, and of more persuasive value, because he has decided the issue in this case, on this contract, and has decided that we are right on our construction. Mr Justice Andrew Baker was not addressed on this point. It went effectively by way of concession, because no one was arguing the point. And Mr Justice Andrew Baker may well have formed a different view. We say he would have formed a different view if he'd been presented with the same arguments that Mr Hollander was presented with. My learned friend's fourth point was that it is a big deal when a court creates a right. That is just question begging, because I'm not asking or inviting the court to create a right. I'm inviting the court, or I invited Mr Hollander, and he accepted the invitation, to read the word, to read clause 14.5 as both the source of the existence and preservation of the rights. So that point goes nowhere, because I'm not asking the courts to create things which don't exist. That's the issue. My learned friend then says, well, both constructions are inelegant, and I can probably accept that. Probably bound to accept that. But he says, both parties posit explanations as to how that came about. We don't. We do not posit an explanation about how that came about. So I'm not entirely sure I understand what is being said that I'm doing. I'm not coming up with an explanation factually. All I'm saying is that the right, which objectively existed, was not very well expressed. I'm not coming up with an explanation of why or how that is so. But my learned friend says, well, if you're faced with Mr Levy's argument of creating rights and his argument of the clauses otiose, his is to be preferred, well, that's an equation which doesn't arise, because I'm not asking your lordships to create a right. That's my first point. And the second point is, the point about the clause being otiose. Of course I accept that the authorities make it clear that one shouldn't get too hung up about otiose words, especially in boilerplate clauses which have been drafted over many years, where the draftsman, I think Lord Newberger in one of the cases talks about draftsmen trying to obliterate every single possibility, and sometimes they'll say use 20 verbs where one verb would do, and then parties try to give meaning to every single one of those verbs. We are, with respect, I'll adopt the same sort of proverbial language about it being a big deal. We are a million miles away from that situation, because what we're left with on my learned friend's construction is not just one word or one phrase or a small element. The entire clause could be struck out. 14.5 is there for no reason. And that's not just one or two words or a subclause, but it's the entirety of clause 14.5. My learned friend's next point was, it's counterintuitive that the creation of the right should come about in the context of a force majeure clause. And it is odd that once there has been a force majeure, then the right is created. I'm not sure if he's just talking in terms of where it comes in the contract. I mean, if that's all it comes down to, that it's at the end of the clause, that would be an odd and not very persuasive submission. But I think his more general point is, why would you create it in the context of force majeure? Well, with respect, the answer to that is obvious. The answer is the parties on this to this contract agreed that the right to repayment only existed in the force majeure context, which is why the clause arises in the force majeure context. And when I say, to be clear, foreshadowing the point I'm about to make, when I say this is what the parties did, I'm not speculating about what they did. I'm just doing what parties do in objectively construing what must have happened in an objective sense. In other words, the parties to this agreement agreed that there was a right to repayment in a force majeure context, but not in other contexts. See, by way of contrast, the position in Totsa, where the parties took a different view and there was a more general right to repayment. So I don't find there to be anything surprising or improbable that the right arises in the context of Clause 14, because that's what the parties agreed, that was the situation in which there was a right to repayment. That's why it only appears there. Learned Friend's next point was he built quite a lot of submissions based on my paragraph 22, where I say the parties went out of their way to preserve a right. That was 22 of my skeleton argument, and he built quite a lot of submissions tackling that point. But with respect, he's misunderstood or mischaracterized the submission I was making at paragraph 22. I wasn't suggesting factually what happened. The parties went out of their way. That is a submission I'm making objectively. When we construe these words objectively, when the court looks at the words, one can see the parties here are expressly going out of their way to preserve something. That is what clause 14.5 goes out of its way to do. And then one has to ask oneself the question, why do parties go out of their way to preserve things that don't exist? Which is my learned friend's case. So, with respect, he's mischaracterized my paragraph 22. But he responds to that point, which I say is a point which doesn't arise, in two ways. One, he says, well, as a response to the way I put my case, i.e. the way I put my case, he says, well, I rely on Totsa. But I do maintain the submission that I made in my submissions in writing. It's wholly impermissible to start speculating, as my learned friend does in his skeleton argument. So clause 14.5 is obviously, it's the pairing, or it's a relic of another clause which did exist and has been taken out, and that's the way it worked. I've made 2 points in my submissions in my written submissions in relation to this. One is that even if there was evidence before the court about how parties had negotiated and drafts passing back and forwards, even that would be inadmissible. But we're now in the wholly speculative world where there's no evidence before the court as to how this contract was negotiated and agreed. So speculating about, I think my learned friend calls it a relic of a clause which must have been removed, is even more impermissible than it would be if there was evidence to support it. And the second point he makes, to support his case, is to rely on the comfort letter. And he says that the comfort letter gives some assistance. Can I just point out one temporal point, which is quite important, is that we didn't see, and I say we didn't see, this is not a factual point, I get this from the contract. The comfort letter comes the day after the contract's been entered into, because the contract is entered into on the 21st, and the way the clause works is that we have to then pay. This is under the payment terms at page 65. The buyer or the buyer's bank shall strictly not later than 22nd of February against presentation by the seller to the buyer of the following documents. So we have to, by the 22nd, pay once we've been presented with a comfort letter, and I do stress these words, issued by the producing refinery in a format acceptable to the refiner, not acceptable to the buyer, but acceptable to the refiner. So all we have to do is, they have to do is produce something that they're happy with. But we don't know on the facts of how this all fitted together. So that's the first point. And the second point in relation to the comfort letter, with respect, I wholeheartedly adopt the observation made by my Lord Justice Newey, is that the fact that the comfort letter doesn't provide for payment in the the fact that it allows the refinery to not to perform its obligations in the context of a force majeure rather takes you back to clause 14.5. So whatever comfort the comfort letter may have given, the one thing we do know is that it couldn't have given any comfort in the force majeure situation, because on its terms it allowed the refiner not to repay the advance in the context of a force majeure. So, in other words, if one is going to look at it at all to construe the contract, it assists my case because it takes you back to at least the contract. And when I say the contract, that must be clause 14.5. Finally, just on my learned friend's point 4, he did mention in passing, he said the fact that it was extended, and we know it was only extended by a month, that also gives an indication that the parties saw the answer to all this in the comfort letter. Well, that simply cannot work as a matter of law, because the court's job here is to construe the contract on its terms at the time it was entered into. What happened, once there was a force majeure, months later, does not assist in any way in understanding what the contract meant at the time that it was entered into. So it is irrelevant, the fact that they did extend it by a month. But as Milady makes the point, it was extended by a month, but then nothing happened, and that was the end of it anyway. And so finally, on implications, which is my learned friend's point 5, I don't think he went so far as to suggest that both the obviousness test and the business efficacy tests need to be satisfied, and that is not the law. It is usually the case that they're both satisfied, but one can well see that in this case, actually, it could be the case that it was only the obviousness test which is satisfied, and not the business efficacy, because the obviousness here arises from the words of the contract itself. It's obvious when one looks at clause 14.5 that the parties objectively understood this right to exist. And so if they hadn't actually done enough to create the right, contrary to all of the submissions I've made thus far, then obviously it has to be implied, because the parties, we can see that they thought it existed.
At the same time, to get this far, it has to be concluded that the position is not obvious from the language.
Yes.
If it had been obvious from the language, then you get the result you want anyway as a matter of interpretation. So if it isn't obvious from the language, well, how can you say that there is obviousness in the language such as to produce the implication?
Well, I think the answer to that would be it is obvious that they thought it existed, but they have not on this analysis. They have not created the right by their words. They have not created it on this interpretation. If I'm wrong on my construction point, they obviously understood it to exist, but this contract has not created it, and so it has to be implied because it is obvious that that is what the parties understood. But I don't accept that both tests aren't satisfied, or put with fewer negatives. In our submission, both tests were satisfied. It would be surprising, which is exactly as Mr Hollander saw it, very surprising that in the case of a force majeure, my friend says it's an honourable stalemate. Well, again, that just begs the question, because what we say is, no, one would much more likely expect that if there's a force majeure and the refinery can't produce the goods that we've paid for, we get our 16 million back. It is a very surprising result that in the event of a force majeure, we get nothing, and we've just parted with our money. And so we do say that both tests are satisfied. My learned friend, his final point was it's implicit. I think that's the furthest he went, is it's implicit in the comfort letter that the money was going to be passed on. We just don't accept that. It's not implicit. And we don't know the exact sequence of the way when the comfort letter was produced. And the fact is, it does not expressly provide that this is how it is going to work. And so, in our submission, if your lordships are against me on my construction point, then exactly as Mr Hollander saw it, is that even if that were not right, then it has to be implied. But obviously, he decided the case on the basis of our primary argument. Unless I can assist the court further.
Thank you very much. Mr Cook.
Just one point. I don't propose to repeat what I said earlier. This is in respect of my third proposition about the language of clause 14.5. I repeat what I said about impair and my submission as to its clarity. My learned friend went to the wording after, and he put some focus on the word the obligation, and as the bench correctly pointed out, it refers to plural obligations. Now, I submit that undermines his point, because his point is that where it's referring to obligation, there it's referring to what is set out in clause 14.5. But it can't, because on his own case, there's only one obligation he's trying to refer to. So there's another one in there on the language that doesn't quite fit. Furthermore, my lords, my lady, if one looks at the two obligations that are set out, the amount of the advance payment or any outstanding advance amount, the term outstanding advance amount comes from the TOTSA clause 10.18, not from the comfort letter. We don't have that clause in our contract. But it does rather, I mean, turning my learned friend's OTO's point round against him, if the outstanding advance amount is the amount of the advance that hasn't been repaid, the advance payment presumably be something else. So what you don't have is any sort of clarity in this provision as to, even if you're using the words that follow, any sound basis for trying to interfere with what I submit is the clear meaning of the word impair. And the only other point I was going to make is my learned friend made a point about the timing of the comfort letter and the contract. I'm afraid I'm not in a position, we have no evidence on that, so I'm not in a position to comment on that, say that they both have the same date that they're entered into.
Yes, I see. Thank you very much. We will reserve our judgments. As you'd expect, they will be provided to you in draft for you to correct our grammar and typing, but not obviously to re-argue the case. I would expect the judgments to be handed down remotely, but even were they handed down in court, there'd obviously be no need for anyone to attend. We'd be grateful if, once you've received the draft judgments, you seek to agree a draft order dealing with consequential matters. If there are any points on which you disagree, could we please have brief written submissions on those points of difference, and we would expect to settle them in the order that we make. Thank you very much, both of you, for your very clear submissions.
Please.